Hi, I'm Scott Hervey with Weintraub Tobin.
And I'm Josh Escovedo with Weintraub Tobin. Welcome to another installment of the briefing by the IP Law Blog. So, Scott, are we talking about trademarks and satanic shoes today?
We are talking about trademarks and satanic shoes today. That's right. So just this past week, Nike, I think it was last week actually, Nike sued a custom shoe studio based out of Brooklyn called Mischief. And this has to do with the satanic shoes that were kind of being marketed by rapper Lil Nas X. The satanic shoe made by MSCHF Product Studios, it's an unauthorized customized version of Nike's Air Max 97. The shoe itself, if you look at it compared to the Air Max, they did do some modifications, like they have a pentagram medallion on the front laces. The inside of the shoe sole has a pentagram design. There's some red design elements, including reference to Luke 10:18. The undersole part, or the cushion part, is red as opposed to clear. And apparently there's a drop of human blood somewhere in each of the 666 custom shoes that Mischief had manufactured and was going to sell. The shoes still had the Nike swoosh emblem symbol trademark, which is probably the biggest factor in the lawsuit.
Right. And speaking of biggest, probably the biggest and most well-known trademark maybe in the world.
I would agree with you. And that was one of the key elements in Nike's claim, at least under their dilution claim, is that the swoosh was and is a famous mark. And I really don't think anybody could argue with that. So, Nike moved pretty swiftly, and they came on with a really strong trademark lawsuit. They sued for infringement, as one would expect. They sued for false designation of origin, and they even had a trademark dilution claim in there. Interestingly enough, Mischief claimed that by the time the suit was filed, they had already sold out of all of the shoes that were manufactured, all 666, that they weren't and didn't intend to manufacture anymore. These shoes sold, I think their original selling price was under $2,000. So pretty expensive for a pair of custom shoes, but sneakerheads pay a lot of money for custom shoes. As a matter of fact, I just looked this morning. They're selling on eBay and Etsy right now anywhere from $8,000 to $20,000. So
wow,
it's pretty amazing. But so Nike moved pretty swiftly. They filed a motion for an injunction and a TRO. At the hearing on the TRO, the court said that they were inclined to grant the TRO, and then in between that time and the actual court's ruling, the parties settled. It seemed like Nike was out for blood, so to speak, but not really. They didn't sue Lil Nas X, which was kind of surprising, but Nike and Adidas both are very popular in the urban hip hop market, and that might not have been very good for their rep, so to speak. And I think really they were just interested in, I don't think that they could have let this one go, right? I think that this was a, this was a case where they needed to protect their intellectual property. The settlement was basically Mischief, the shoe studio, will ask customers who bought the shoes to return the shoes for a refund. Obviously, those customers that have already received shoes, and apparently not all shipped, but those that receive shoes, they don't have to return them. They can choose to keep them. And if you're a sneakerhead, and given that the fact that some of these shoes weren't shipped and will never be shipped, it probably makes them even that much more valuable that, there aren't that many of them floating around out there.
Yeah, I think that's exactly right, Scott. I mean, I'm not a full-blown sneakerhead, but I do like sneakers. And so I do know that when like a new Jordan's released, if they make a mistake and it's a factory error, those Jordans will actually sell for exponentially more than the pairs that would have gone out already. And as we all know, those shoes already sell for a pretty penny. So I imagine that given that this is such a limited production, I think some of the owners would be crazy to actually return it because they
Yeah,
they
no,
really
I
wanted to, they could
agree.
just
I mean,
sell.
from a value perspective, it just makes a lot more sense for those sneakerheads that were lucky enough to get the shoes to hold on to them. There are a couple things about Nike's lawsuit that I want to talk about, and then a position that was being made by the defense is really interesting, and I want to talk about that last. But so Nike, of course, as one would expect, they brought a claim for trademark infringement. In their complaint, they included evidence that showed actual third-party or consumer confusion. They introduced in the complaint a number of social media posts saying, how they're appalled that Nike is issuing a shoe that is satanic or has satanic features, and that they're appalled, that they're disgusted, and they're never buying Nike again. They can't believe that Nike would do this. What a disgrace. It's pure evil, et cetera, et cetera, et cetera. So, pretty good showing of actual confusion, actual consumer confusion, which is, one of the hallmarks of establishing likelihood of confusion. If you can show actual confusion, you're almost all the way there. The other elements, I mean, it's a shoe, it's got the Nike swoosh, it's sold online. I think on their trademark infringement claim, if you do the analysis under the Lanham Act, under the multi-factor test like Sleekcraft or AMF that is used to analyze likelihood of confusion for goods and services, I think Nike wins hands down. And you can tell I'm kind of leading into what Mischief's attorney presented as their theory for defense. But before we get there, I want to talk about Nike's dilution claim, because that was a little interesting. Usually dilution claims involved the unauthorized use of another's trademark on products that don't compete with or have little connection with those of the trademark owner. So it's kind of strange that Nike included a dilution claim when the allegedly tarnishing or diluting goods are shoes, and Nike primarily sells shoes. But I think they were just kind of throwing the kitchen sink at Mischief, and I don't think they really, I don't think there was much discernment into the claims that they brought. I thought, that was just an add-on claim. And I don't know, push come to shove, actually, that it would have been sustained. The real interesting point of this little skirmish here was the position that Mischief's attorney was taking in their defense. I mean, they never got around to filing an answer, but there was a statement to the press made by Mischief's attorney. They basically said that these shoes are not an infringing brand, but individually numbered works of art that were sold to collectors, released by a company that was trying to push the boundaries of today's culture through storytelling and performance art. The lawyer's statement continued that given the artistic expression that is at the core of the Satanic Shoes project, Nike cannot prevail on its trademark claims. The First Amendment protects this expression and bars any relief on claims of trademark infringement or dilution. It's the Rogers v. Grimaldi test.
Right. And that's exactly what I was thinking, was that is an interesting position. I thought, hey, we're back to Rogers versus Grimaldi again. And the sad thing is, I mean, I guess everyone else is better off with a settlement, but this seems like a situation that would have been ripe for the Supreme Court to review the Rogers versus Grimaldi situation, because as we know, they refused to take up the squeaky dog toy Jack Daniels case. But this here, I mean, when I look at this shoe, I think the same thing you do, Scott, about the infringement claim. I mean, it seems pretty clear cut. So I think the only way that you potentially see the defendant walk away from this without getting slammed with a substantial judgment would be if they bring Rogers versus Grimaldi in and prevail on that claim. But if they did that, I can assure you Nike would be appealing the matter. It obviously wouldn't have any relief at the Ninth Circuit, which is where I assume this would take place since Nike is based in Oregon.
Actually, they filed it in New York, where
Mischief
is based, right? So in either event, right, your Ninth Circuit or Second Circuit, you're dealing with Rogers v. Grimaldi. So the Mischief might have prevailed, right? They just had the show just above zero, right? 0.0001 in artistic expression. So I think they win there. Then the matter is, is there any express statement or express action of confusion, right? Then the question becomes, is leaving the Nike swoosh on there, does that satisfy that element? Maybe not, right? Because that's the whole purpose of Rogers v. Grimaldi is balancing First Amendment expression and using the mark of a third party in an artistic work. So, if they took the swoosh off, then we probably wouldn't have a case here, really. So it would have been really interesting. It would have been really interesting because I guess the fundamental issue would have been, are sneakers works of artistic expression? Are they similar to a sculpture or a painting or a photograph?
I think the answer is yes. And I'm sure you could have gotten a sneakerhead expert witness who would have been happy to get on the stand and talk about how sneakers are art. But I think clearly the answer is yes.
I mean, they certainly sell for as much as some pieces of artwork, maybe more. I mean, and a lot of collectors, they put them in lucite boxes. They're portrayed and displayed at homes and in offices as if they were works of art. And clearly a lot of work on Mischief's part went into this whole project. There was an artistic purpose behind this. It wasn't just kind of half-baked thought. It really would have been interesting to see what the Second Circuit would have done here.
I agree with that. Unfortunately, I think the economic disparity between Nike and a boutique custom shoe designer wouldn't permit that case to make it to even a summary judgment stage.
I don't know about that, Josh. Mischief had a lawyer from Debevoise and Plimpton, and that's no slouch of a law firm. So who knows? Who knows where this might have ended up had Mischief decided not to settle.
That's a good point, Scott. Unfortunately, I guess we'll never find out.
We'll never know. Thanks, Josh.
Thank you, Scott.
Thanks for watching. Hope you enjoyed our discussion about trademark infringement and satanic shoes. Please remember to subscribe to our channel and check back frequently for additional content. And also check out our blog at theipLawblog.com.